now, like every time that I do a movie, like the first note is like in the script, in the execution, in the marketing, in the editing, they're always like, okay, we got to make sure she's likable. And I went to my husband one day and I was like, have you ever gotten the note where they like, we want to make sure this guy's likable? My husband's like, nobody's ever said that. And my husband plays deeply unlikable people, but you love him. You know, and like women, they're like, they gotta be likable. And you're like, what is that? What does that even mean?
You know, I was lucky to be able to be involved in so many different aspects of this movie, not just on screen. On screen is the smallest amount of work that I did in this film, to be honest. I took the relationships with my mother or my sisters or my children and my feelings, and I mean it's all over this film, and in ways that nobody will ever know, and I'll never tell anybody. But when I sit in that theater with my loved ones, they see themselves all over this film. Moments we've had together, things we've said to each other. And I think that's why I feel so proud, and it's so personal to me.
And I think that more than any movie I've ever done, like Lily is such a ball buster. I am rotten to the core when it comes to that. Like if I'm not busting your balls, then you should be worried. Then I'm mad at you. Then I don't love you. The way that I sort of use humor and levity in moments of sadness or pain, because that's the prism through which I can cope and deflect. I smile in sad moments because it's just how I process things. I'm not a person who has like, you know, a lot of outward like rage or anger. Like I'll get upset about things, but I'm not yelly. I'm, you know, quite even and patient, and so the way that I react to a situation, you know, instead of doing like exactly what's on the page, if she's gonna react this way, I may feel the exact same feeling, but I may not react the way that it's written that she reacts. And so I really tried to overlay the honesty of my heart and emotions onto Lily, and I think that that's why the performance is one that I'm very proud of, because
narcissistic individuals often exploit the court system by filing excessive motions and making unreasonable requests. Their goal is not just to access unnecessary information but to intimidate the opposing party, drive up legal costs, and use litigation as a tool for harassment. Frivolous lawsuits are incredibly common, and Ryan Reynolds and Blake Lively's case against Justin Bond is built on falsehoods. A couple of weeks ago, they issued subpoenas to major telecom companies like Verizon Wireless, AT&T, and T-Mobile, seeking over 2 years' worth of phone records. They attempted to access not only the records of those directly involved in the lawsuit but also third parties and anyone they could potentially link to a so-called smear campaign. They wanted data dating back to 2022. Justin's legal team pushed back, arguing that this request far exceeded the scope of civil court. Since this is not a criminal case, the individuals involved have a right to privacy. Moreover, the requested timelines and the extent of the information sought were unreasonable. Blake's team reacted as though Bond's attorneys had no right to contest the subpoenas, insisting they were entitled to the information. They framed Bond, Wayfair, and other involved parties as if they were trying to conceal something. However, just like the previous gag order request, the subpoena did not go in their favor. It's likely that their attempt to secure a protective order will fail as well. There's nothing more satisfying in legal proceedings than when a narcissist loses and the judge sees through their tactics. Today, Judge Lyman ruled on the motion to quash the subpoena, granting it in part while denying a minor portion. The judge's response to Blake's side was particularly telling. She faced a sharp rebuke. The dispute over the subpoena centers on the excessive scope of information being sought, including sensitive records like call logs and locations, which are beyond the limits of civil court. To address these concerns, the judge ordered a meet and confer session, requiring both sides to negotiate and attempt a resolution. This directive was clearly outlined in the court order. After meeting and conferring, Lively agreed to remove references to all documents, eliminate the request for location data, and clarify that the subpoenas would seek only call and text logs, limited to non-content numerical data reflecting incoming and outgoing messages. She then modified the subpoenas accordingly. However, on February 24, 2025, the Wayfair parties reiterated their request to quash them entirely. Their primary objection remained that, even with these modifications, the subpoenas still covered call and text logs revealing the phone numbers of anyone the Wayfair parties and others had communicated with, regardless of whether those communications were relevant to the case. The Wayfair parties requested that the subpoenas be further limited to communications between specified phone numbers belonging to parties and witnesses that Lively would identify. Lively, in contrast, argued that the subpoenas were justified because they could lead to admissible evidence about not only the defendants but also a broader network involved in an alleged smear campaign against her. She also contended that the Wayfair parties lacked standing to assert privacy rights on behalf of non-parties. Judge Lyman, applying Rule 26(b)(1) of the Federal Rules of Civil Procedure, weighed the relevance of the requested records against the asserted privacy interests. He ruled that, even as modified, the subpoenas remained overly intrusive and disproportionate to the needs of the case. The broad request for phone records from December 2022 onward raised significant privacy concerns. While Lively had excluded the content of messages, the call logs alone could reveal sensitive information, such as contacts with doctors, psychologists, or personal acquaintances. She had also failed to demonstrate a way to separate relevant numbers from those unrelated to the case. Lively had argued that these records would help her identify others involved in the alleged media campaign against her. However, the judge pointed out that her own complaint stated this campaign began in August 2024. It was therefore unclear how obtaining phone records from 2022 and 2023 would be relevant. More broadly, the court found that Lively had not provided a valid legal basis to justify such broad discovery. She already had access to discovery tools to obtain phone numbers of individuals she had identified, but using subpoenas to uncover potential additional participants was deemed an improper, fishing expedition. As a result, the judge ruled that the subpoenas seeking phone records of the Wayfair parties must be quashed. However, this ruling was issued without prejudice, meaning Lively could serve more narrowly tailored subpoenas limited to relevant information. The court effectively told Lively that she had overstepped legal boundaries, abusing the subpoena process in an attempt to obtain records she was not entitled to. The ruling reinforced that the Wayfair parties had legitimate privacy rights, and her arguments were overly broad and legally unsound. Interestingly, Lively's stance on privacy appeared contradictory. She argued that the Wayfair parties had no right to privacy when it came to phone numbers, yet she sought attorneys' eyes-only protections when it came to discovery concerning third parties and witnesses. This inconsistency weakened her position. One additional footnote in the ruling addressed Lively's suggestion that the phone records could reveal when and how the defendants and witnesses became aware of her harassment allegations. However, the court found she had not adequately explained how this information was relevant to her claims. The judge ruled that she could not use subpoenas to uncover when individuals learned about her allegations against Baldoni and Wayfair, as it fell outside the scope of the case. The one aspect the judge did not quash related to third-party phone records. The Wayfair parties lacked standing to object to subpoenas directed at non-parties, as they had not demonstrated a legal basis to assert privacy rights on behalf of those individuals. Therefore, the motion to quash was denied concerning those portions of the subpoenas, without considering the broader implications. Instead of taking responsibility for the backlash, Blake and Ryan have attempted to shift the narrative, framing themselves as victims of a politically motivated attack rather than acknowledging their role in the controversy. At the core of this dispute is the misuse of power, whether through the media, legal maneuvers, or corporate influence. The judge's ruling on the subpoenas is a reflection of that imbalance. Lively attempted to leverage broad subpoenas to uncover information beyond the scope of her claims, and while she was partially successful in being allowed to seek records from non-parties, the court largely sided with Wayfair in quashing the overreach into private phone records. What's particularly frustrating about the media's coverage is its selective reporting. Rather than objectively presenting both sides, outlets like the New York Times have seemingly taken Lively's claims at face value, dismissing or ignoring the substantial evidence presented by Wayfair and Baldoni. This failure to engage with both sides fairly is not just irresponsible journalism, it actively fuels misinformation and division. The attempt to frame this case as a left versus right political issue is another tactic used to manipulate public perception. The reality is that both parties involved, Lively and Baldoni, are Democrats. The idea that anyone questioning Lively's claims is doing so because of partisan bias is absurd. It's a distraction from the actual facts and a deliberate attempt to discredit legitimate scrutiny of her case. Candace Owens and other conservative commentators have been vocal about their skepticism, but that alone doesn't mean their concerns are invalid. Dismissing them solely based on political affiliation ignores the fact that there are also liberal commentators and independent journalists who see the flaws in Lively's claims. A truly fair analysis would recognize that skepticism toward her case isn't rooted in ideology but in the inconsistencies in her narrative and her strategic use of media influence. Furthermore, the notion that there was a smear campaign against Lively remains unproven. The evidence she has presented thus far does not substantiate her allegations, and insiders have provided conflicting accounts that challenge her claims. Sony's internal politics and the resignation of its CEO further complicate the story, making it clear that there were other factors at play beyond the supposed efforts of Baldoni and Wayfair. Ultimately, this case is about accountability. The judge's ruling reinforced that Lively cannot use the legal system as a tool to conduct a fishing expedition, nor can she weaponize the media to control the narrative unchallenged. If journalists were doing their job properly, they would be scrutinizing both sides rather than amplifying one perspective without question. In any legal dispute, facts matter more than feelings. The reality is that the backlash Lively and her team are facing is a direct result of their own actions. Instead of taking responsibility, they have chosen to shift blame and create distractions. But no matter how much spin is applied, the truth will ultimately come out, and when it does, it won't be determined by political allegiances, but by the evidence. It looks like this is a closing section for a video or article, addressing an audience and encouraging engagement. Would you like me to refine it for clarity and impact while keeping your tone intact? Let me know how you'd like it adjusted.